Under section 91, evidence terms of a contract, grant and other disposition of property reduced to form of documents. When a transaction has been reduced to writing, either by agreement of the parties or by requirement of the law, the writing becomes the exclusive memorial thereof, and no evidence shall be given to prove the transaction, except the document itself or secondary evidence of its content, where such evidence rule is based on the principle that the best evidence of which the case in the nature is susceptible should always be presented. This rule does not demand the greatest amount of evidence which can possibly be given of any fact, but its design is to prevent the introduction of any which, from the nature of the case, suppose that better evidence is in the possession of the party. Adopted for the prevention of a fraud. For when better evidence is withheld, it is only fair to presume that the party has some sinister motive for not producing it, and that if offered, his design would be frustrated. The rule thus becomes essential to the pure administration of justice. The best evidence about the content of the document is the document itself, and it is the production of the document that is required by this section in a proof of its contents. The section lays down the best evidence rule, but does not prohibit any other evidence where the writing is capable of being construed differently, and which shows how the parties understood the document. By this process, the parties were able to show that they intended to enter into a transaction of mortgage and not a sale. The surrounding and the attending circumstances are relevant for the construction of a document only when some ambiguity exists in the document and not otherwise. This section, when the terms of a contract, grant or any disposition of property have been reduced to the form of documents, or where any matter is required by the law to be reduced to the form of document, then the document itself or the secondary evidence of its content must be put in evidence. The first proviso refers to a transaction voluntarily reduced to writing. The second refers to those cases in which any matter is required by law to be reduced to the form of document. Example, sale of immovable property of the value of rupees 100 and upward, mortgage for an amount exceeding rupees 100 and upward, mortgage for an amount exceeding rupees 100, a lease of immovable property for a year at least, a trust of immovable property, a gift of immovable property, etc. There are two exceptions to these provisions. When a public offer is required by law is to be appointed in writing, and any officer has acted as such, the writing need not be proved. When a will admitted to probate in India may be proved by its probate. The general rule laid down in this section is also subject to the exception laid down in the following sections 95 to 99. The sections has no application when the writing is not evidence of the matter reduced to writing. This section and section 92 define the cases in which the documents are exclusive evidence of a transaction which they embody. They only apply when the document evidencing of a contract appears to contain all the terms thereof. The inferences that a writing was intended to contain the whole of the agreement may be drawn from the document itself as well as from extrinsic evidence. Section 93 to 200 provides for interpretation of a document by oral evidence. A contract, being a creature of an agreement between two or more parties, has to be interpreted giving literal meaning unless there is some ambiguity therein. The contract is to be interpreted giving the actual meaning to the words contained in the contract, and it is not permissible by the court to make a new contract. However, reasonable if the parties have not made it themselves. It is to be interpreted in such a way that its terms may not be varied. The contract has to be interpreted without any outside aid. The terms of the contract have to be construed strictly without altering the nature of the contract, as it may affect the interest of either of the parties adversely. 22. Exclusion of evidence of oral agreements. This section operates only as between the parties to a deed or their representative in interest. It has no application to strangers and does not therefore prevent a stranger from showing that a transaction which on the fact it purports to be one thing was in fact never intended by the parties to be that, but was effected for some collateral purpose, and that real transaction between them was something different, but such case must be pleaded and proved. Under this section, when the terms of a contract, a grant, or any other disposition of property have been reduced to the form of document, or when any matter required by law to be reduced to the form of document have been proved by the production of the document or by giving secondary evidence of its content, no evidence of any oral agreement or a statement shall be admitted as between the parties to any such document or their representative in interest for the purpose of contradicting, varying, adding to, or subtracting from its terms. There are 6 exceptions to this. Number 1, any fact which would invalidate any document or entitle any person to any decree or order relating thereto may be proved, such as fraud, intimidation, illegality, failure of consideration, mistake in fact or law. Number 2, any separate oral agreement as to any matter on which the document is silent and which is not inconsistent with its term may be proved. Number 3, any separate oral agreement constituting a condition precedent to the attacking of any new obligation under the document may be proved. Fourthly, any subsequent or oral agreement to rescind or modify any such contract or grant or disposition of property may be proved except when such contract of a grant is required to be in writing or has been registered. Fifthly, any usage or custom by which incidents not expressly mentioned in any contract are usually annexed to such contracts may be proved if they are not repugnant to or inconsistent with its express term. And sixthly, any fact which shows in what manner the language of the document is related to existing fact may be proved. This section supplementary to section 91 and is to some extent implied in it. If a contract, grant or disposition has been reduced into writing, section 91 says no evidence shall be given of it except the document itself, and this rule would be in a vain unless, as it is said in this section, it was also forbidden to contradict, vary, add to, or subtract from its term. The bar of this section applies only when it is sought to be proved that the terms of the transaction were different, and not that the transaction itself was different than what it purports to be. The section applies only where upon the face of it the written instrument appears to contain the whole contract. The parties have intended to reduce all the terms of the contract into writing. Then no parole evidence is admissible. But if they intended only to reduce into writing a portion of the terms of the contract, then they are entitled to give parole evidence of the terms which they did intend to reduce into writing. This section is only applicable to cases as between the parties to an instrument or their representative interests, where however the dispute is between the stranger to an instrument and a party to it as his representative interest, this section is inapplicable, and both the stranger and the party or his representatives are at liberty to lead evidence of oral agreement, notwithstanding the fact that such evidence, if believed, may contradict, vary, add to, or subtract from its term. Where however a transaction is contained in more than one document, the document should be read and interpreted together, and this section is not applicable. A contract made on the basis of a tender is in writing. Initial terms were not allowed to be brought in either on oral basis or by conduct of the officers of the authority making payments on different basis.